Again, my name is Ryan Williams. I'm the president of the Claremont Institute. Just started at the beginning of this month. We're a nonprofit. Oh, thanks, Bob. So we're a nonprofit, as all of you know. We have the privilege, because of that, of relying on all of your generous support for about 98% of our operating budget. We sell a few magazines, but other than that, we rely on all of you. So I'd like to recognize some of those here today who go to great lengths to support our important work. We have Claremont Institute board members Roy Crummer, Bob Curry, and Ed Erler. I haven't seen him yet, but Keith Carlson, a 2007 Lincoln Fellow of ours. Keith, with his local law firm, Carlson and Jayakumar, helped make today possible as a sponsor. And we have an annual host committee that helps make a lot of these events possible. Richard Christie, Roy Crummer, Robert and Wendy DePietro, and Scott Thornton are all here today, host committee members. And then, as John mentioned, we run summer fellowship programs, and we have Julia Ariza and Dr. James Rosenthal, who sponsored summer fellows for us. So please join me in thanking them as well. And finally, John mentioned, although he left out one important detail, we have distinguished Claremont alumni of our fellowship programs gathered here today, John Eastman being one of them, Joseph Tartakovsky, John Sullivan, and Phil Munoz, all of whom are participating in our program. So as John mentioned this morning, our mission at the Claremont Institute is to restore the principles of the American founding to their rightful preeminent authority in our national life. Our activity over the years undertaken to advance this goal has taken many forms. As circumstances change and new political and intellectual problems come before us, we have to adapt and change accordingly. We've been around almost 40 years now, so our activity has changed quite a bit as we've seen new problems crop up. But our core work has always been the same, and it will continue to be. Our long-serving distinguished fellow, Harry Jaffa, called it the scholarship of the politics of freedom. A good phrase, we think. So as important as day-to-day policy, law, and even horse race politics is, we're instead in the ideas business. I always find intelligent debate and disagreement clarifying, so let me challenge a commonplace saying these days, especially amongst conservatives, to illustrate my point a bit or illustrate our mission. So you often hear today about politics being downstream from culture. We've always disagreed with that formulation. It's not that culture isn't important, of course it is. To deny that would be foolish. It's just that in decisive ways, culture is past or old politics, and especially politics at the fundamental level, at the foundings, when certain ideas about human nature, rights, justice, and government get put in place and shape the way of life of a place, even a national community. That's why we're in the ideas and scholarship business. Because as culture is downstream from old politics was ultimately shaped by some foundational set of ideas about who we are and how we ought to live together. The founders of this country, we think, and we've spent our careers and our existence as the Claremont Institute studying these things, we think the founders got these principles right. It took a while and some constitutional amendments to live up to those principles. See Abraham Lincoln and the Civil War as just one example, and perhaps the most important one. But beginning over a century ago, a new set of founders, a new set of ideas, went to work attacking that old view, politically and intellectually, that old view of the founding. I'm speaking, of course, about progressivism and its many offsprings since. As a result, our politics today has been shaped, I think, decisively by a new set of ideas about man and government. It hasn't all been a straight line. Politics is messy. Political history is messy. And we've stemmed the tide at many points and at many moments. But the principles of the founding, I think, though still around, are hardly dominant. And we investigated this morning a few ways in which that's the case, and we'll continue to talk about that for the rest of the programming today. In many ways, I think our crazy on-the-ground politics today over the last 2 years can be seen as a kind of crisis or inflection point in this clash between the old and the new, one that's didn't just arrive on our doorstep 2 years ago, but has been going on for a century. Fundamental disagreements about principle tend to take a while to bubble up, and they do so in different ways. And so we have much work to do. That work for us, John mentioned some of it, I'll fill out the rest, consists of teaching America's thinkers and statesmen, the current generation and the next, those fundamental ideas that ought to inform day-to-day politics, policy, and law. We teach in our summer fellowship programs for young and mid-career leaders in policy, political journalism, media, and the law. We have 600 alumni now from our fellowship programs over these almost 40 years. They're working across the country to advance our mission and restore and improve limited government and constitutionalism. We have, for example, about 25 fellowship alums in the current administration scattered across it. They're doing great and necessary work in government and outside it, in New York, in DC, and across the state houses across our country. And so we work with them in our alumni programming to knit them together as a community and to continue to teach them as well. So we engage ideas about man and government, politics and history, ideas and culture, all these things in our flagship publication as well, the Claremont Review books, and through important books and essays written by our senior scholars and fellow travelers. And we take, of course, this high-minded fight to the courts through the work of John Eastman and our Center for Constitutional Jurisprudence. So to wrap up and extend the analogy a bit that I started with, as ideas and founders are upstream from today's politics and culture, the Claremont Institute, at our best, we're upstream from the many think tanks, media outlets, and policymakers doing their important work in Washington and across the country. Or, to add a metaphor to the analogy, forgive me, we're wholesalers to their retail operation. We want to equip these folks with the proper principled ideas about government because the policy battles are downstream from the battle of ideas. So this is really work we love, and it's a great joy for us to undertake. We're grateful for all of you for undertaking it with us. After all, we have the greatest country in the world to save. So thank you again for all being here with us. And thanks for indulging that summary. We're going to get to what you're really here for at lunch, the main event. So let me introduce once again my colleague and friend, John Eastman. As most of you know, John is a passionate and public-spirited advocate for this country's founding principles, and he's been a lifelong student and teacher of them. He holds a law degree from the University of Chicago, a PhD from Claremont Graduate School, where he was a student of the late and great Harry Jaffa. John was a Supreme Court law clerk for Justice Clarence Thomas, as was mentioned earlier, and he was also a Claremont Publius Fellow. He's been teaching law here at Chapman for many years, and he's been involved in keeping the constitutional lights on, so to speak, here in California for many, many decades, and our state and our country are in his debt. So please join me once again in welcoming John.
Thank you, Ryan, and thank you, all of you. So Ryan mentioned that the Claremont Institute's been around for nearly 40 years. Half of that time, the Claremont Institute Center for Constitutional Jurisprudence has been around. We founded that in 1999, and we've been involved in 120, 130, 150 cases. So many of recent years, we're losing track of the number. Before the Supreme Court and also in a lot of lower court matters. Anytime the major principles of the Constitution are at stake or at risk, we're involved, and it's become quite a full-time job of late, I must say. But some years ago, we decided to honor those public officials who, in their careers, had advanced the cause of the recovery of constitutionalism in America. It's named the Ronald Reagan Jurisprudence Award. And you might think that odd for lawyers because he was not a lawyer and he was not a judge. And yet we've named this award in his honor, partly because in his administration, he turned the tide on this question of restoring constitutionalism. He did it himself, and he did it with a couple of key advocates in his administration, both of whom are prior recipients of this award, Ed Meese and Judge Bill Clark. We've also given this award out to some very distinguished jurists. Janice Rogers Brown, who sat on the California Supreme Court. I always affectionately call her Justice Brown, even after she went to the D.C. Circuit Court of Appeals, and she would always remind me, there is no justice on the D.C. Circuit Court of Appeals. And Judge Alex Batchelder as well. This year, we are honored to have as this year's recipient of the award, Judge Edith Jones. Judge Jones is originally from Philadelphia and then ended up in Texas. I was living in upstate New York at one point and then moved to Texas. And one of the things we'll talk about here is which border is most important to Texas, the Red River against the Yankees or the southern border. There's a dynamic about Texas, but she has been on the Court of Appeals for the Fifth Circuit since 1985, starting to approach one of the longest serving members of the Court of Appeals in our nation's history. And I think she started in that when she was only 6, so it's really extraordinary. But during the course of her career on the Court of Appeals, she has been a stalwart defender of basic constitutional principle and manifested in her opinions an understanding of the theoretical foundations of our Constitution that is one of the most profound of any judge on the bench today. There are a handful of such judges, and we've honored 2 at the Supreme Court with our Churchill Statesmanship Award as well, Sam Alito and Clarence Thomas. Many of you may recall that but for a heartbeat of a decision, she would have been there as well. The nod ended up going to David Souter, but I think in hindsight, and many of us knew at the time, even not in hindsight, that our lives would be different today if Judge Edith Jones had been Justice Edith Jones ever since then. It is It is my great pleasure and deep honor to invite her up here to accept our Ronald Reagan Jurisprudence Award. How often did you speak to Ronald Reagan?
Hello? Can you hear? 2 times. The first time was in 1976 at the 25th anniversary National Review banquet at the Plaza Hotel. And Ronald Reagan, this was in the fall, and he had not yet announced that he was going to run for president, but many people expected him to, so he was in the receiving line, and we said hello. That's the first time. And the second time was when he nominated me to the Court of Appeals, and that was amusing because he, unlike most other recent presidents, he spoke personally to every person that he nominated to the courts, and I think that indicates how important he thought the courts were. But I was at my office. My secretary yelled at me, Mrs. Jones, the White House is calling. So I zoomed down from whatever I was doing, and there he was. You know, he was on the phone, and this was in 1984. And I said, well, Mr. President, saying we shook your hand in 1976 before you were going to run against, or 70, maybe it must have been 75, because it was going to run against Ford. And he said, I knew you would do well. And then at the end he said, thank you to you and your husband, Woody, and your 2 boys. And I thought, well, isn't that nice?
Well, you were at the time, I think, general counsel for the Republican Party in Texas or in Dallas County or something?
That was for the state Republican Party, and that was a rather short-lived appointment. That was only a couple years. It's one of those things on the resume that lives with you forever. But I did get exposed to Texas election law of the time and on the ground floor of the federal election laws because we started having to advise clients. But Hans von Spakovsky will probably knows this, but at that time the CFR governing federal elections was, you know, a thin document that really wasn't a huge problem as it is today.
As it is today. So before we get to you know, you've got some very interesting cases recently dealing with voting law issues. I'll talk about those in a minute, but I want a little bit more of your background. Moving from Philadelphia, a Philadelphia lawyer, down to Texas. I mean, you weren't a lawyer yet, but the Philadelphia to Texas move is a culture shock. And I did it in high school. You did it for law school. I remember, they had this one Yankee in class, and they decided to do a mock trial of Harry Truman as if the United States had lost the war and he was on trial for war crimes for dropping the bombs. And who did they make Harry Truman but the Yankee in the class? And there was no question how this trial was going to come out. So I'm wondering if you had similar experiences on your move to Texas.
Well, I was 1 year old.
Oh, okay. Okay. They didn't make you Harry Truman then.
But I am the product of a mixed marriage because my dad grew up literally as a cowboy in Sinton, Texas, near Corpus Christi on the Texas Gulf Coast. And you know, my parents exhibit what America can be because my mother grew up in Lancaster, Pennsylvania, and although it was the 30s, she was #1 in a class of about 600 students in high school and got a scholarship to go to Dickinson College. Daddy was at the top of the pre-med school at University of Texas in Austin. Denton Cooley, the famous heart surgeon, a couple years ahead of him, and he got a scholarship to go to Yale Medical School where they met. And he was in residency at Penn when I was born. And then he dragged my mother, that's the culture shock. He dragged her back to San Antonio, and so I'm really a Texan.
Okay, very good, very good. Now, I want to talk about some of your opinions, and I've noticed a discouraging trend. What in your early parts of your career were mostly majority opinions, some of your most significant opinions in recent years have become dissenting opinions. And the reason is, I mean, most of the courts of appeals in the country have gone over to the dark side, as it were, or emulating the Ninth Circuit with increasing fervor. I always thought that the Fifth Circuit had remained rock solid, but given the fact of the number of dissents you've risen to reach, that may not be the case anymore.
I will not speak ill of my colleagues. I will say the decisions speak for themselves.
Yeah, okay, very good. Well, let's take up a couple of those, and you know, there was a speech you gave at the University of Virginia back in 2003 that was a pretty much no-holds-barred speech criticizing the Supreme Court's aggressive activism in changing our culture, from criminal procedure to cultural issues to questions on abortion, and this was long before the same-sex marriage controversies as well. But that was a pretty hard-hitting speech for a judge. You seem to be more willing to criticize the court than a lot of judges are. How has that played out for you?
Well, it depends on whom you read. I mean, I suppose it might have assisted in getting this award, which honors me very much, but I think a lot of I don't read my own press, but a lot of it has been extremely negative about things like that. But I do think that if a judge can't speak critically of and I wasn't talking about individual judges, I was talking about the train of decisions, mostly by the Warren Court in the 60s, and how they had fundamentally affected culture, and see no reason to have changed my views since 2003. Somebody has to say these kinds of things.
There was a case that came before you a decade or so ago that actually has its roots in a case some 40 years ago, Roe versus Wade. The original Jane Roe of that case filed a petition to reconsider her own case in Roe versus Wade. Norma McCovey versus Hill is the name of the case. And I thought what was most interesting about this is you faithfully applied the law and said she really doesn't have standing to bring this case or what have you.
Right.
And that was the majority opinion authored by Judge Edith Jones. And then there is a separate opinion written by Judge Edith Jones saying, okay, I know what the law is, but Roe was an exercise of raw judicial power, she says, quoting Justice White in his dissent. The perverse result of Roe is that the facts no longer matter, she writes, that the court's constitutional decision-making leaves our nation in a position of willful blindness to evolving knowledge. That happen should trouble any dispassionate observer, not only about the abortion decisions, but about a number of other issues in which the court unhesitatingly steps into the realm of social policy in the guise of judicial adjudication. Now that decision is one of many that is why we're honoring you today, but it sounds an awful lot like the youngster who doesn't know that he shouldn't be saying the king has no clothes or the emperor has no clothes, and we thank you for that. But I'm wondering what kind of, how that played out. I don't want to ask for the internal conversations in the court, but maybe how it played out elsewhere in Texas and around. Have you gotten feedback about that?
Oh no, I've gotten more feedback about that than about anything else I've ever written in 32 years, but it was very short. My colleagues stood mute to a person.
Yeah, I did notice that as well, that you wrote alone there. This is the kind...
Well, I'm talking about more than two others.
Yeah. Well, these are the kind of things that need to be said, it seems to me. There are a couple of other...
That's why you honored Janice Rogers Brown and Alice Batchelder and Clarence and Thomas and Alito and my friend Scalia. So.
Right.
Yep.
So there was another case of recent years. Again, these were both written. Just a bit of procedure here. The courts of appeals almost exclusively operate by 3-judge panels. And the judges who sit on those panels are randomly drawn. But there is a mechanism to have the entire Court of Appeals district consider a case en banc or the full court. And I notice with increasing frequency, even when you're not on the panel, there may be a call for an en banc review. And then when your colleagues turn it down, you take that opportunity to write a dissent from the denial of en banc in order to lay out the arguments that need to be made. And I'm thinking one in particular here, just from 2 years ago. This was one of the Little Sisters of the Poor cases,
yeah.
One of the many, East Texas Baptist University versus Burwell. Judge Jones writes a dissent from denial, and you can often tell a lot what's going on in footnotes in these opinions. There's a wonderful footnote quoting George Washington's farewell address. Of all the dispositions and habits which lead to political prosperity, religion and morality are indefensible supports. And quoting John Adams' own letters to the same effect, if religion and morality alone can be established, which can establish the principles, it is religion and morality alone which can establish the principles upon which freedom can surely stand. The only foundation of a free constitution is pure virtue. One of the things that has stood out about your jurisprudence over these last 3 decades is your willingness to recognize the importance of moral virtue in the cultivation of citizenship and in the securing of the foundations on which our whole Constitution rests. Did these come to you? Do you kind of reach out for them to try and articulate that, or?
I am not. I have great respect for you and Professor Ullman in this audience, and Harry Jaffa and Walter Burns, and people I would have studied with if Cornell hadn't been falling apart when I was there. And I have such great respect that I do not want to be presumptuous and tendentious about, blathering on about things in which I could be not exactly accurate. So when I use these quotations, I'm very careful. I do try to put things on the proper plane, I did have one case in the list I gave you, which I was looking at again this morning, called Veek versus Southern Builders, that might appeal to some businessmen in the community, because the issue in that case had to do with electrical and plumbing codes that are adopted all over the United States for minimum construction standards, and the trade union of building, plumbing or electrical contractors claimed that they had a copyright on that code, so that a small builder, Mr. Veek, in some tiny town in Texas, would have to pay $500 to get a copy of the code so that he could do his work. And I thought, I wasn't on the panel, I thought, well, that isn't right. The law can't be copyrighted, because this is adopted in the municipal codes of all these deals. We went en banc on that, and that ended up in a 9-6 decision in which we said it wasn't the law is not copyrightable.
That's good.
I mean,
yeah. You would think there would be a lot of other common sense resolutions like that as well.
Well, now that you said no, okay, I'm gonna steal a mic here. There has been an event in recent history in which the court was divided, and there are 5 women on our court now and 10 men, 9 men, but for one man who I appreciate, but it was all the women against all the men. And at the end of the voting, I said, now we know where the common sense is on the court.
Oh, very good. Well, let me touch on a couple of other of this. So
Being blunt carries a price.
What's that? Well, any successfully married man understands that without question. So I just, and if we don't understand it, we're told that we should. Okay. So I mean, the breadth of cases and the controversial issues that you have confronted, they range from some of the issues we're going to be talking about this afternoon on deference doctrines. One of your cases just a couple years ago dealt with a guidance memo out of the Department of Education defining what procedures, or rather lack of procedures, universities must employ if somebody's alleged to have committed sexual harassment. And you wrote a very strong dissent in this case, Plumer versus University of Houston, that's saying, just because it's in the college setting doesn't mean we get to pretend that there aren't due process protections. Now, that would seem pretty obvious and constitutionally compelled, and yet you're writing in dissent there. Is there even on the most solidly law-abiding court in the country, is there this kind of trend to follow social wins, do you think?
Yes.
Okay, good. Yeah. Okay.
Well, a better way to put it is that, and again, this is not personal about my colleagues involved in that case, but a lot of federal judges are much more sensitive to criticism than one would like to think, and they are also sensitive to being on the wrong side of what's perceived to be history.
Yeah.
So this is the power of the executive branch. When the executive branch declares that something shall be, which it did in those Title IX guidance letter, which is promulgated without notice and comment, without any even arguably democratic safeguards, and has led to great, at least 1,000 very difficult cases around the country. The judges say, well, it's a federal government, isn't it? I mean, we have to defer.
Well, I will say this. I think one of our singular successes at the Claremont Institute Center for Constitutional Jurisprudence is we started raising those issues and concerns, the basic separation of powers concerns, in our briefing to the Supreme Court about a decade ago. Justice Thomas starts picking it up. Neil Gorsuch down on the 10th Circuit picks it up.
Alito did.
Yeah, Alito did.
Scalia was getting on board.
Scalia was on board, even to the point of wanting to overrule his thing. And this is now open for reconsideration in a way that 10 years ago nobody thought was even possible. So thank you for kind of keeping those issues alive with cases like that. You talked about the way many judges kind of respond to public perceptions or public media coverage of them. So I'm wondering, when there's a line in the recent case from a couple of years ago dealing with Texas voter ID law that you have. No one doubts our unwavering duty to enforce anti-discrimination law, but in this media-driven and hyperbolic era, the discharge of that duty requires a courage to distinguish between invidious motivation and shadows. The ill-conceived, misguided, and unsupported majority opinion shuns discernment. Now, I'll bet that won a lot of friends, both in the local media and on the bench, but this kind of bold clarity in your opinions to just tell the truth where it needs to be told.
You didn't even quote my Area 59, did you?
No, I didn't. Well, the majority emulates the clever capacity of Area 51 alien enthusiasts who, lacking any real evidence, espied a vast but clandestine government conspiracy to conceal the truth. And truth is in quotes. What brought you to have such forthright candor? I mean,
I can't tell you about that.
Yeah, no, not in that particular case,
Yeah.
but just generally.
Well, I grew up around the dinner table where my father's pastime was spouting politics, and I guess I can sum it all up by saying he was a cowboy. He was a brilliant doctor, actually. But he used to talk politics with his patients all the time. But you could sum up his views. His heroes were Darrell Royal, the famous coach of the University of Texas football team at the height of its success, and John Wayne. Just straightforward, there's good and bad, and that created a great deal of problems in our family in the 60s and 70s when my younger siblings were rebelling. Created a great deal, but you grow to see the wisdom of that later on, and the more I became familiar with what was going on with the rule of law in the constitutional and other areas, you have to be candid at some point.
Let me go to that, because last March down in Dallas at the Philadelphia Society meeting, you gave a very important speech. Can the rule of law be saved? And you outlined both what the principal elements were of what's necessary to have a rule of law and how every one of the elements are under attack. I wonder if you'd like to kind of elaborate on that a little bit for us. It's an extremely important speech.
Well, thank you. Larry Iron invited me to speak. I was afraid I was going to be eaten for dinner by that crowd because they're very astute. But I've been thinking about this virtually. I had the privilege to go to Iraq and was the highest ranking federal judicial official to do that. It was in March of 2010. Iraq was pacified. They had just had a national election, which had gone forward smoothly. Everything looked pretty good then. But there were several incidents. One of them was that their Department of Justice building had been blown up, and the Minister of Justice had to live in his office for 2 years under armed guard because it was too dangerous. The rest of their judiciary were housed in the green zone, like a battle-hardened zone where the Americans were and so on. And people said to me that they will go after the rule of law first. If they can undermine the rule of law, the government is gone. And then I met with women judges, and one of the women judges said to me, Iraq coming out of the civilian system, people go into a training program that leads them into the judiciary. And she said to me, and I do not admire the civilian system completely. I like our system. But she said to me, how are people trained to be judges in the United States? And I went back to the usual deal. Well, you're civilian lawyers, and you're supposed to have some acquaintance with the law and so on. And so we have, but it's a very provocative question because the fact is that people go on to the bench, and in particularly the federal bench, in an era in which, starting in probably at least in the 60s or 70s, we are not trained in the fundamental constitutional principles and how to uphold them. I was not. I was fortunate enough to learn about it. I'm just wandering on here. But my point is that you have there is a realistic problem. Every judge thinks he or she is following the oath and doing what the law requires without really having the deep appreciation of the underpinnings of the separation of powers, the limited role of the judges, what does it mean to interpret the law as opposed to make it. So in this speech, I said, here are the principles of a legal system, and they start out with intelligibility. Everybody can read the law and know what it is. Generality, the law applies to everybody, high and low, without respect of persons and positions. The law ought to be have fair procedures, because if the procedures are twisted, as we see from the trial of Thomas More, the outcome is twisted. And what are my other two criteria? I had two other criteria: democratic accountability, and transparency. People have to know what the law is. The law is not going to be copyrighted behind a screen that you have to pay for. You have to know what it is. Well, it's pretty self-evident that, just to make a long story short, just in one example, in the administrative area, we have a lot of law that's not transparent. We have a lot of law that's made by agencies with who knows what agenda that is not democratically accountable in any way. We have a lot of law that is not intelligible, which spurs the move to change the Obamacare, to change the tax code, and many areas of judge-made law are barely intelligible. And then I had a few choice Supreme Court decisions where the court itself has manipulated procedures in certain areas in which certain results seem to be preferred. So those are great challenges that we face.
Let me pick up on that last point, and the relationship of a Court of Appeals circuit judge with the Supreme Court, because you're compelled, if you're taking your oath seriously, to follow their thing. We've got some judges out here in the Ninth Circuit that think a different view of that, so you get a case like Roe versus Wade or Planned Parenthood versus Casey, that is the higher court authority that kind of governs the Court of Appeals decisions. You have to, in many ways, comply or conform with those holdings, and yet in a couple of very important cases, for example, Texas Medical Providers versus Lakey, upholding a Texas law, the required informed consent, required doctors to show sonograms. And what struck me most is that you relied on language in Casey itself, even though I suspect you probably disagreed with the opinion in Casey. How often do you see the court's decisions create a dilemma for how you're going to issue a ruling in the case?
Fairly often, but the dilemma exists because of uncertainty in applying the law, and so there are a lot of not everything is a moral dilemma, and I have thought about what circumstances would require me to resign from office, and I thought about it very much after a couple of recent cases. So as the antidote to that period of sort of distress, I gave a speech about great dissents in the Supreme Court.
Oh, very good. Well, and we hope you continue to engage in those great opinions, and that one day soon you'll have a couple of additional appointees to your court to turn them from dissents back to majorities.
There you go.
There was one other case that I thought was particularly interesting, and there's a big grand fight about in the country now about originalism. This battle royale that Ed Meese and Ronald Reagan launched to recover the notion that when the Constitution is clear on something, that ought to govern the legislative, the executive, as well as the judicial branches. And then there's another view that the Constitution is infinitely malleable, and it only means whatever the last pronouncement of 5 members of the Supreme Court thinks it means. This doctrine of judicial supremacy rather than constitutional supremacy. You took issue with that modern doctrine in a recent case involving the Second Amendment and the right of 18 to 20-year-olds to be able to exercise Second Amendment right. Now, 18 and 20-year-olds, last I checked, they can be drafted and they're handed a gun to go, and they can vote. But this law didn't allow them to actually have a gun on their own private possession otherwise. And you've got a great line in there. Originalism is not without its difficulties in translation to the modern world. And you cite Justice Scalia's opinion in Kylo, dealing with thermal imaging devices and whether that violated the Fourth Amendment, something I'm sure James Madison spent a lot of time thinking about. But then you bring it back to, first of all, the fact that 18 or 20-year-olds could carry a weapon was right in the core of what they understood. But I think you went deeper into what the principle at stake was, and this development of a principled originalism that your jurisprudence embodies is very encouraging to see. But I wonder if you have a few more comments about that 18-year-old carrying guns case.
Well, you know, there are some decisions of what I get very irritated when the Supreme Court makes a pronouncement and then basically it dies. And U.S. v. Lopez was one of those. I thought that was where the court said that there was a limit to federal criminal law based on the Commerce Clause. And that was the Gun-Free Zones Act. It said, what does that have to do with interstate commerce? And at the time, I and some of my colleagues thought that was going to start to rein in the idea that in northern Texas, for instance, the U.S. attorney was prosecuting people who would do armed robbery of one convenience store, saying that interfered with commerce. Well, that's just a dumb idea, but no court in the United States that I can recall extended Lopez. Our court voted 2 times whether to limit this kind of prosecution with no effect whatsoever on interstate commerce under Lopez, and the following that, Morrison, I think. Anyway, we lost by 1 vote each time. In this case, it was the consequences of the Heller decision. I think Justice Kagan said after Justice Scalia died, we're all originalists. I know she said we're all textualists now, and I think something about originalism too. You can believe that if you like. But the courts, a lot of the implications of Heller have yet to be explored by the Supreme Court is a fair way to put it.
I think that's right. Well, and Justice Kagan's perfectly consistent. We're all textualists now, but the text, like Humpty Dumpty, means whatever I think it means. And so her views of that are perfectly consistent with her living Constitution view. Well, we're at the end of our time. Please join me in thanking Judge Jones for our wonderful conversation here. Presented to the Honorable Edith Jones, United States Circuit Judge, U.S. Court of Appeals for the Fifth Circuit, recipient of the Claremont Institute's 2017 Reagan Jurisprudence Award, presented by the Claremont Institute and the Center for Constitutional Jurisprudence. Thank you, Judge Jones.